Up next, we're going to, as Siri alluded to here, a presentation on, I know many folks may or may not know, Minnesota has enacted what we call red flag laws, aka extreme risk protection orders. Some of us refer to as ERCOs, but we'll have a little information on that from Raina Alexander, who is Assistant County Attorney in our office, and Bridget Laverca, who is a Victim Service Specialist in DASC as well.
All right. Good morning, everybody.
Morning.
I'm Raina Alexander. I am a assistant county attorney with Hennepin County. And I came to Hennepin County in June of 2024 to manage the extreme risk protection order kind of process for Hennepin, for our attorney's office, but also for all of our Hennepin County partners. So I do a lot of training and technical assistance for our office, but then for law enforcement, for mental health providers, for schools, for advocates, for pretty much anybody who will let me come in and talk with them about extreme risk protection orders. I might look familiar to some of you because before I was here, I was at Standpoint for 19 years, where I held a number of different roles. And I've been working in Standpoint is a domestic violence, sexual violence organization that gives legal advice to domestic and sexual violence victims and to the folks who work with them. And I've been working in the domestic violence field for 28 years now. So that's a little bit of my background, how I come to this. Bridget, do you want to introduce yourself? Yeah. Sorry, there was an open door back here.
Hi, I'm Bridget Laverca. I'm a legal service specialist with the county attorney's office. I always like to say that's kind of a fancy word for community advocate. So in addition to helping Raina do technical assistance and training, my main role is to be stationed at the Domestic Abuse Service Center, where I meet with people to discuss if filing an extreme risk protection order is the right way to go for them. So what that means is I'll meet with you in person or on the phone. I know Hennepin County is very large, so getting downtown can be difficult. So just calling me, I explain what the protection order will do for you, the process, and then if you decide to file, we'll file together. Okay, so we'll just give some background, the next couple slides about how extreme risk protection orders came about. So these are stats from 2023, specific to Minnesota. There's 525 gun deaths in Minnesota. 81 children and teens were victims of gun violence. This stat is very much higher in the United States as a whole. On average, one person is killed every 17 hours in Minnesota by a firearm. Firearms are used in the majority of homicides, so 65%, 47% of those were suicides. And then domestic violence, homicide, 16 of those were gunshot. And again, just to kind of give you an overview, also with firearms, there are more firearms in the United States than there are people. Just some other statistics. So 5 times access to gun makes it 5 times more likely that a woman will die on the hands of a domestic abuser. Nearly 6 million women reported having a gun used on them by an intimate partner. And nearly half of mass shootings with 4 or more people killed if the perpetrator shot an intimate partner or family member. Each year on average, at least 1 in 8 prohibited gun purchasers denied by a background check are denied due to prohibiting domestic violence histories.
Thank you.
Yeah, sorry. So 16% fewer intimate partner gun homicides. So laws requiring people who have had abused their partners to turn in their guns are linked to 16% fewer intimate partner gun homicides. So how and why ERPOs were developed. So the first group convening in March of 2013, so this was after Sandy Hook, to identify new practices and policies based on research. They determined that they wanted to use a civil process to temporarily remove firearms from someone when they are a clear threat to themselves or others. So a lot of words that I always like to use and encourage everyone to use if you're ever talking about extreme risk protection orders is that it's civil and it's temporary. So it's a temporary process for a very extreme and serious situation. It also gives judges clear and legal authority to order the firearm removal. Gives law enforcement clear legal authority to remove the firearms. So this develops the extreme risk protection order policy following that meeting. So just overview of ERPOs. Again, they're civil orders. They were modeled off orders for protection. They are civil orders with criminal repercussions. ERPOs enjoin and prohibit the respondent temporarily from possessing or purchasing firearms. It creates a formal process for the respondent to depossess themselves of their firearms either by voluntary compliance or through a search warrant. So this is unlike orders for protection. So when I meet with people, sometimes people come in and the respondent, they already can't, own the firearm, legally own the firearm, right? So we can do, even 14-day, we'll get into more relief for extreme risk protection orders, but this could give us potentially a warrant to go in and law enforcement to actually physically remove those firearms. It also flags the respondent in NICS, so this is the background check system to prevent further firearm purchases. There are two types of extreme risk protection orders, and you can do a situation where it's either or together. So there's an ex parte that lasts for 2 weeks, and then there's long-term orders that last 6 months to a year. So California actually passed the first modern day extreme risk law. They called it the Gun Violence Restraining Order, or GVRO, in 2014. We passed ours in 2023, and it became law in January of 2024. As of April 25, 21 states, DC, and the Virgin Islands have extreme risk protection order laws. And each state calls it differently. Sometimes people call it red flag, or people will use the term purple as well. I, like Raina, don't like that name, so I am very to spell things out so it doesn't cause confusion. So there's just a lot of different terms for this law. So they can be used in a variety of circumstances. So threats to self, like you saw in the statistic before, suicide has a high rate with firearms, and then it can be threats to self and others, and then threats to others. So domestic violence, workplace violence, school shootings, and then community violence. So this is research to date. Extreme risk protection orders have been used in response to threats of suicide and interpersonal violence, including mass shootings. Most petitioners are law enforcement. Implementation varies greatly within and among states. Local champions are critical to implementation uptake. So this is a new-ish law, and so part of mine and Raina's role is to make sure the community knows that this is available for them to use as a family or household member. And then one life saved for 10 to 20 firearm removals. So the Hennepin County Attorney's Office response, so new position was created. So Raina, our attorney, does training and technical assistance. I started in May of this year, so I'm doing, like I said, direct advocacy to family and household members, and then I'm also helping with training and technical assistance. So we really want to help. Please reach out. Tell your neighbors. We're all very active in the community, and so this is how we can help people and let people know this is an option. Oh, yeah.
So, do you coordinate with the mental health section of our office, adult services, if there's a need for Greco? And also, what about juveniles? Do you answer the question?
That's a legal question.
Yes, we do coordinate with with our adult protection, unit, and, absolutely. We send actually every year, our PO goes over to Julia every time one is granted in Hennepin County. And I research if there's been any commitment proceedings or if law enforcement says in their petition that somebody had a mental health hold, I flag that for Julia, so that y'all can, track that and see what's going on. Juveniles, well, just like with orders for protection, our statute is silent. So, they are people, and so arguably, why not? But yeah, our statute is just like the order of protection statute where it doesn't, the ERPO statute doesn't say anything specific, but they are a person, and so arguably, yes. And when you think about the background of where these statutes come from, they come from like, we kind of originated out of school shootings, so then that idea helps motivate the belief that these should be able to be used if there is a juvenile. We haven't had any of those yet in Hennepin County, and nobody's appealed the issue, so I can only give you my personal legal opinion on that. It's a good question, thank you. All right, and please ask questions, folks, because it's great, I love questions, thank you. All right, we're gonna talk about the statute now. So we kind of gave you that background, Bridget gave you the background. We're gonna talk about the statute. We're gonna do a high level overview. So the factors that the court can consider are specifically laid out in our statute. And there are these 9 things that the court is supposed to consider. And so that's a history of threats or acts of violence towards somebody, a history of attempted use or threatened use of physical force towards another person, violating any court orders, which include but not limited to other ERPOs, 260C orders, which nobody knows what those are, but seem to only show up when people talk about taking firearms away, or orders for protection. If somebody has a prior arrest for a violent felony or a conviction or prior arrest for a violent misdemeanor, stalking, domestic assault, conviction for offense of cruelty to animals, unlawful and reckless use, display, brandishing a firearm, suicide attempts or serious mental health issues, or they've been named in an extremist protection order, a 260C order, or an order for protection. So this is the list that's in our statute. The statute does also say that the court can consider any and all evidence that is helpful to it in deciding whether or not to issue a ERPO, an extremist protection order. So some things that I know that we'll regularly reference that is not listed here, harassment restraining orders, I think are a really big one, especially if we're seeing really scary behavior. Harassment restraining orders often show up in a variety of different ways. So that's one. One that's also not on here would be substance use. So if somebody is significantly struggling around substance use, alcohol, drugs, prescription drugs, illegal drugs, so all of that I think can be really helpful to the court to understand why somebody is maybe not safe with a firearm, right? If somebody all of a sudden they're in their 40s and now all of a sudden they're having hallucinations, the court may wonder, that's weird, why 40 years old? All of a sudden we have no mental health background, they're starting to have hallucinations. Understanding that they're a significant heavy meth user can really help the court understand. Right? And so these are, just like when you're writing an order for protection, it's all about helping the court understand what's going on and why, so that we can reach our threshold of a significant danger with firearms, right? And we've also included, we didn't have a conviction for cruelty to animals, we had somebody who was using a BB gun within the city of Minneapolis shooting squirrels. And it was in a way like their kids were there and it just felt really icky. So we included it to kind of show the disrespect around firearms. So who can petition? And so this is one of the things that's unique around extremist protection orders, is that law enforcement can petition. And it puts law enforcement in this very kind of new, unique position for them of being the petitioner in a civil action, which is not where they're used to being. So law enforcement, a city or county attorney can petition, the guardian of the respondent, and that's an actual guardian, like somebody who has been legally appointed a guardian, not somebody who says, I am their guardian, not somebody who says, I have power of attorney. This is somebody who has legal guardianship. Or a family or household member. And this is a much more narrower definition of family or household member than we are used to when we think about domestic violence or domestic abuse under our statute. This includes only spouses and former spouses, parents and kids, persons who presently reside together, or people involved in a significant romantic or sexual relationship. Folks who are not included in this definition of family and household member that we tend to think of as family or household member if you do domestic violence work is folks related by blood, people who have resided together in the past, folks who have a child in common, or folks who have a pregnancy in common. All right, so grandmas and aunties, unless they're living together right now, they are not going to qualify as a petitioner on their own. But don't worry, if somebody doesn't qualify to be able to petition themselves, they can always go to law enforcement and talk with law enforcement about the possibility of filing that petition. Right? So that's the option for them if they don't qualify.
Can you talk a little bit more about child in common?
Yeah. What do you want to know about child in common?
Yeah, so what does that mean? Is it?
What does child in common mean?
Yeah, so if you were married to a person and you share a child in common with that person, you cannot petition.
No, because now you're a former spouse, so you would qualify as a former spouse. These are folks who were not married, had a child together and are not currently living together, and we can have a whole conversation about whether that includes they were involved in a romantic or sexual relationship, and whether this statute involves past significant romantic or sexual relationships. That's a whole different discussion that we don't have there. But yeah, so it would be somebody who had a child with somebody and they were not married and they don't meet the other qualifications. Okay. So as Richard already alluded to, ERPOs look, if you are familiar with the order for protection process, ERPOs will look extremely familiar to you. They feel very much like an order for protection process. In fact, they are handled out of our family court here in Hennepin County. You would see, if you do order for protection, you help folks with them, you will see all the same judicial officers. It's the same court administration staff. So it's all the same folks, and it's gonna feel the same way. And in the same way of order for protections, there is first, most folks will apply for the emergency or ex parte order for protection, extreme risk protection order. Ex parte just means on one's own, it's Latin. I call it the lawyer preservation language because like people who aren't lawyers hear Latin and they freak out and they think they need to get a lawyer. And so just like in orders for protection, with an extreme risk protection order, no hearing is held at this stage, right? You fill out the petition, it goes in front of the judicial officer and the judicial officer of the day, and the judicial officer of the day will decide based solely on the petition whether or not to grant that emergency extreme risk protection order. Right now, they actually, unlike orders for protection, which could go in front of anybody who's the judge of the day, right now in Hennepin County, they're solely going in front of Judge Corey and in front of Judge Robin, who are seeing these right now as on the emergency side. Just like in an order for protection, although we may not always think about it, the petitioner can request a hearing for a long-term order, but doesn't have to. If no hearing is requested, but unlike an order of protection, if no hearing is requested, that ex parte order will expire in 14 days. If you are looking at doing these, there are 2 boxes. And if you want one that goes for 6 months to a year, and you want the ex parte, you need to check both boxes. It's a little confusing. We've had law enforcement make this mistake a couple of times. So you gotta check both boxes. If the court finds probable cause in that protective or in the petition, if the court finds probable cause to believe that the respondent possesses firearms, and if there's enough information to tell the court not only do they possess, but where they possess those firearms, then the court has to issue a warrant to take possession of all firearms. The respondent's gonna get an option to voluntarily comply prior to the execution of that warrant, but it's all gonna happen all at the same time. Law enforcement's gonna show up where they show up, and then they're going to say, we got a search warrant, and you can voluntarily comply. But if you don't, we're gonna execute our search warrant right away. And there's a question. let's get you the mic.
Can you talk about how specific the description of the firearm needs to be, or the location?
So the specificity, I mean, do the best you can. If you know it's a handgun, then say it's a handgun. If you know it's a shotgun, say it's a shotgun. If you don't know any of those things or what any of those words mean, say a gun. But then where, like, the court's we need to know where to issue the search warrant for. It just can't be law enforcement running around all these places. So you need to be able to say that the gun is at their home or the gun is on their person all the time. We've done that before. If they keep it at work, you know, or we had one, it was in the car, it was in the glove box or the console of the car, right? So if you know, but if you don't know where the gun is, then we're not gonna be able to, highly unlikely you're gonna get a search warrant. So needing to know that. And there's a form that you fill out, it's ERP 103. And Carrie's gonna correct me and tell me somehow I said something wrong. Just teasing.
Thank you. I was just gonna add, we actually had one denied because we couldn't describe the gun enough. So any possible description you have, I would throw in there. I don't know if that was a one-off by that judge that was reviewing that day, but that was a bit frustrating because I don't know if I could describe a gun, so.
Yeah. So, do you wanna add?
I was just gonna add that, when I meet with people and ask them, like, is it long, like, do they hunt with it, like, is it small black, like, how many shots, you know, what, as much as you can describe, and then that kind of tells me what specific gun it could be.
And I assume, Carrie, you mean you have the search warrant part denied, not the ERPO denied. Right. So you can get the extremist protection order and not get a warrant. And you may have circumstances where you don't need the warrant. Sometimes law enforcement's taking all the firearms and so we don't need a warrant. Sometimes the respondent doesn't have any guns yet, but they're making threats. They're saying, I'm gonna go to Shields and I'm gonna buy a gun and kill myself. Right? So then we want an extremist protection order to prevent them from buying any firearms to help to make sure they don't harm themselves. Right? So there are reasons why we may not want a warrant. And then a long-term order is the other type of order, and a hearing has to be held within 14 days, so keep that in mind. Again, if you do orders for protection, you might be used to the fact that there are a lot of types of relief we can get without having a hearing. Of course, you can't get firearm prohibitions without having a hearing, but we have to have a hearing in an ERPO if you want this to last longer than 14 days. We have that hearing, then the court needs to decide by clear and convincing evidence, which is a higher standard than we see in orders for protection. So orders for protection is preponderance of the evidence. Clear and convincing is the standard we use to terminate parental rights. So it's a higher standard. And the court is used by clear and convincing evidence, a significant danger of other persons, or significant danger to other persons, or is at significant risk of suicide by possessing a firearm. Is there a question?
Sorry if you're gonna get to this, but I have a couple questions. So first, what is the teeth in this? Like, how soon are you gonna get to that? Okay, and then my other question is, you just briefly mentioned like to prevent them from getting a gun. How is that communicated out, or is it not, like as far as purchasing firearm?
Yep, so your extremist protection orders are entered into NICS, which is a national database that's run by the feds. That whenever somebody is purchasing a firearm, they have to be run through NICS. Court administration enters that information into NICS, and our court administration is on the, as they're doing all of their regular paperwork to push that sucker out, they're also entering it into NICS. So we actually had a situation last year where we had a woman who was she was struggling with her mental health and she was suicidal. A family member got an ERPO, and later that day she went to Shields to try to buy a firearm and she got flagged. She didn't even have the order yet. It was actually, there was a whole bunch of learning that we did in that process because it was very early in ERPOs, but it was able to prevent her from buying a firearm. Yeah, Glenn.
I really like this idea. I see it's a Minnesota state statute. Is all of law enforcement in on this and supportive of this?
I can't speak for the entire state of Minnesota, and I won't, but I can tell you that our city law enforcement across Hennepin County has been they've really embraced this. From our small cities to our big cities, Minneapolis, Carrie was just talking, Minneapolis has filed, I think you guys have 12 so far this year? Just you guys? It might be more. Oh, it might be. We've had 63 filed so far in Hennepin County. I can guarantee every single one, if you read those petitions, you're just so glad that this law exists. From all sorts of things, from people who are struggling, talking about harming themselves, to people who are talking about harming other people. So yeah, I think Hennepin County is doing an amazing job. What's happening in other cities, other counties, you know. Alright. The length of that order is going to be between 6 months to a year. Almost always they're a year is what I'm seeing. There's a couple of times where things have been less than that, but almost always they've been a year. And there is a renewal or extension process that one can ask to have after after a year if you want to apply because somebody is still struggling and we're concerned about their safety. You can apply to extend the order. So there is, unlike orders of protection, there is a formal transfer of firearms process, and that can be, they can temporarily transfer their firearms, and we always remind folks this is a temporary order. They can temporarily transfer their firearms, or they can make the choice to permanently transfer their firearms. That's going to be up to the respondent. So they get to make that choice on how they want to do that. If the court did not issue a search warrant, then the respondent needs to, according to the statute, as soon as reasonably practical, but not any longer than 24 hours, they have to give those firearms to either a federally licensed firearm dealer, otherwise known as an FFL, who is able to charge a reasonable fee to store those firearms. They can give them to law enforcement, who has to accept the transfer, and they are not allowed to charge any sort of storage or associated fee. They have to turn those firearms over to any law enforcement agency. And that makes sense when you think about it in a variety of ways, like say if somebody gets an ERPO against me and I have a hunting cabin up in Monoman County, but I live down here in Hennepin County, we certainly do not want me driving to Monoman County, taking my firearms and driving them all the way back down here to Hennepin County to hand them over to Minneapolis, which is where I live, right? So we want to be able to give those to Monoman County so that they can hold them because we don't want me driving around with firearms when I'm not supposed to have them, right? So any law enforcement agency has to accept under the ERPO, and they're not allowed to charge any storage or any fees. The only time that a relative can take possession of these firearms is if the firearm itself is an antique firearm, curio, or relic as defined under federal law, and then that relative has to obviously be legally able to possess a firearm, and they need to not live with the respondent. So that's also very different than orders for protection, right? Because orders for protection, that's what we see a lot of, right? Is that the respondents are giving their firearms to a family or a friend or somebody else. And sometimes they can legally possess and sometimes they can't. But, and then everybody has to, there's affidavits that they're supposed to file. Those affidavits get filed with law enforcement, attesting to the fact that these things have occurred. So offenses, it's a misdemeanor if you possess while an ERPO is in effect, and that's similar to orders for protection, but ERPOs are not enhanceable, unlike order protection violations, and it's also not a shall arrest. These are may arrest, and they are also not, they're not warrantless arrests. If one was convicted, they would be convicted of the misdemeanor and they'd be prohibited from possessing for 5 years. They are also added to the folks who are ineligible to possess a firearm or ammunition under 624.713. And so while the extreme risk protection order is valid, the respondent is unable to not only possess firearms, but they are also not allowed to possess ammunition. Which is kind of a surprise sometimes to some folks because the ERPO statute only talks about firearms. But our legislature added to the list of ineligible people to be able to possess those who are restrained from possessing by an ERPO, and that also includes ammunition. If somebody does possess, it's a gross misdemeanor. It's going to void all permits to carry and transferee permits. And then it's gross misdemeanor if you file a petition that's materially false with intent to harass, abuse, or threaten, so don't do that. Alright, so what other stuff is helpful to know? So I'm moving, so I was like, is there a question? Alright, so, do you have a question? Oh, yes, perfect, sorry.
Quick question about the storage. I'm just curious, since the statute passed, how is it, I know we can't speak to other counties right now, but in terms of Hennepin County, how has that been going in terms of who is taking accountability of the firearm in terms of the local precinct versus the county, right? And then in terms of also maybe where is the state taking a role in this? I know there's been a lot of conversations on the state level in regards to this issue.
Yeah, so locally, all of the circumstances that I am aware of in Hennepin County, it has been the city of residence of the respondent who is taking those firearms. So like, I know Minneapolis has like 90 not Minneapolis, you guys might too, but I'm thinking of is Minnetonka has 90 firearms and 500 pounds of ammunition that they took off of somebody. They gave up counting, they just plopped it onto a scale. That one was a yes. But it's being held by the local law enforcement. There are and have been some grants at times offered by the state to help law enforcement build up their capacity to hold firearms. This is one of the things that makes them the most nervous because they just the capacity to hold 90 firearms and 500 pounds of ammunition for a year, 2 years, 3 years, it's a lot. But you know, they're doing what they need to do in our communities, that's for sure. Other things to know about, under this statute, mental health professionals, they have, the statute creates a duty to warn for mental health professionals, and this is separate than their other duties to warn that exist in other statutes. Mental health professional is specifically defined in statute, so if you're wondering if you are one, you can go look that up. And if you as a mental health professional believe that your client is a serious threat of physical violent behavior, or you determine that your client presents a significant risk of suicide by possessing a firearm, you have to communicate that threat or risk to the sheriff of the county where the client resides and make a recommendation to the sheriff regarding the client's fitness to possess firearms. So this is it's a little different than their other statutory duty to warns because A, it includes, you have to communicate the threat to the sheriff, whereas under the other statutory duty to warns, you communicate the threat to the person who the threat is against. This also includes suicide. And it's really important that you communicate it to the sheriff because there is liability protection in the statute, but that is tied to calling the sheriff and making the report. It's very specific in the statute. It's one of the things I want to fix in our statute, but that is what it says right now. So call the sheriff if you need to make this report, and then your liability protections will apply. But we always like to point that out because trying to get that word out. Yeah.
So for mental health professionals, we get notified, but then they don't wanna come in and testify at the hearing claiming privilege. So, and obviously we can't get medical releases signed because it's against the individuals, so should we be reaching out to like Hennepin County Sheriff or Hennepin County to ask you guys to help with, like, should officers be doing, search warrants for their medical records? Should we just be subpoenaing? I'm running into when I just subpoena a medical professional and say I'm throwing you on the stand, they get real mad at me.
Yeah, I bet they do. I think we need to figure out better ways to do this, and I think we should talk about it because I'm a very fierce advocate of protecting privilege, and we also have this stuff in the statute. So I think we need to talk about how this works. I would say it would be. We need to talk about it because I agree that it's an issue. I think the court's been giving us some reasonable latitude, but I don't know for how long that's gonna go on. So yeah, we should talk about it. Health records. The statute tells us that all health records and other health information will be protected from public disclosure, but you as the filer need to fill out the forms correctly and do the things. It is upon the person, the petitioner, to make sure that you've done the stuff that you need to do to protect any any health records. Those records will be provided to law enforcement. But always, it's important to know, any information in the petition will be public information. ERPOs are public, and they are very public. They are, while orders of protection are technically public after service, right? Like, you have to go down to the courthouse, and so you gotta come down and do a thing. ERPOs, you can find those on Remote MnCRO, and you find them the second that it gets filed. So they are very public. And so it's important to keep that in mind, to think about whatever you're putting in that petition is public information. Obviously, you can't Google search stuff and it won't show up in Remote MnCRO, but still, you should know that it's there. And, question?
What is being done in regards to getting guns from juveniles and having parents be responsible for having guns taken from their homes and doing searches regarding juveniles?
So we haven't had any specific situations right now in Hennepin County that have come up involving juveniles. And it's definitely conversations that we've been having about, so who are you taking the firearms from when you show up in a house where you have juveniles and you have parents? We did have a situation that spanned multiple jurisdictions last year that involved an adult, but there were all these allegations that the adult had firearms at their parents' home, and their parents actually lived in 2 different counties because mom and dad were not together. And then we had the respondent living here in Hennepin, and then we had the actual crime happen over in Redwood County. It was a little bit wild. But our philosophy was, we had the search warrants, we went for firearms, we went and we took all the firearms and we'll figure it out later. The parents then claimed, well, these are all our firearms, and we said, well, if you can prove they're your firearms, and again, this was an adult not living in the home, and we said, well, if you can prove they're your firearms, well, then we can give those back to you, but we're also gonna remind you that if anything happens with one of these firearms, and that, if your son uses them to harm somebody, there will probably be civil damages and potentially criminal liability for that. When they tried to argue the firearms from his home were theirs, we were like, no, we're not doing that. So it might look similar with juveniles, we're not sure yet. And that's part of the fun of a brand new statute as we all try to figure it out. So the statute talks an awful lot about sealing of the record. It has all this language in there about how we're gonna seal in these circumstances and we're gonna seal in those circumstances. And the Minnesota Supreme Court said, wait a second. The Minnesota Supreme Court said, first of all, the word seal means something very specific to us. And the word seal means that nobody, except for the extreme upper echelons of court administration, can see that document or that record. And they said, judges can't see it, and law enforcement can't see it. They said that seems kind of problematic, because that completely disrupts all what you're trying to do. If it's sealed, we can't set it to NICS because it's sealed. And nobody can see it. And so they said, we're not gonna do that. We're not gonna seal things because you're using a word that doesn't work with what we do. And then they also threw around the Constitution, and they're like, remember that whole separation of powers thing? Hey, you legislature, we don't tell you to do with what to do with your records. What are you doing telling us what to do with our records? And so what the Minnesota Supreme Court said is, we're definitely not gonna seal anything. But if somebody wants a record or the case file to be marked as confidential, they need to ask. They have to motion the court and ask for it to be made confidential. And how that has played out has been a little wild. Sometimes it's a document that's confidential, sometimes the whole thing is confidential, it just kind of depends. But from everyone that I've seen in Hennepin County, you can still see it, and you can see the fact that it happened, okay? And I point this out solely because I've had lots of people, well, lots is a strong word. We've had a few people end up in court saying, well, the statute says you have to seal. Yeah, I get the statute says that, but we have court order that says that's not what's going to happen. All right, so I like to prepare people. I know the statute says one thing, court's gonna do something else. And then some things to think about. Law enforcement is going to be involved. And I know that's not great for a number of communities. But they are going to have to be involved. They're probably gonna be the ones that serve. If there's a search warrant, they absolutely have to be involved. Bridget and I have tried to convince to let us go and do search warrants and kick down doors. Keep being told no. Something about liability, whatever. So law enforcement is definitely going to be involved. And so if you're working with somebody, being really upfront, and that may be a barrier, we understand. We have to be really upfront and honest with folks about law enforcement is definitely going to be involved. They may be showing up at their door, they might be pulling them over to figure out how to, execute this, to serve and to execute the search warrant. It's more than likely gonna be local PD, which might mean, maybe they've got a big beef with Hopkins and they live in Hopkins. So it's probably gonna be Hopkins that shows up at their door. And that might be an inhibitor, right? So being just really honest. And then is the respondent legally able to possess? If they're not, that could lead to criminal charges, right? If law enforcement comes in, they're removing firearms off of somebody who is not legally able to possess, it's a gross misdemeanor, for most things, and a felony if they are not able to possess because they have committed a crime of violence in the past, right? And so, that's also something to consider. I know I had that conversation actually when the statute was kind of new. I was talking with a lawyer in a family court situation, and they were concerned about a respondent that they had who was making some noise, and they were nervous. But the respondent at some point had been involuntarily committed, and you were prohibited from possessing if you've been involuntarily committed. And so that kind of played into the decision to not file because they didn't want them to be arrested.
So my question is, because a lot of my clients have a problem with working with the police. What is an alternative? So is there any alternative, especially if we have cases where they really need to follow through with this? And it's like life-threatening, what is the alternative, or is there an alternative?
Bridget's gonna talk about safe storage and those types of things. But there isn't a court order type option because all of those are gonna require law enforcement to serve. But that's actually an excellent segue into Bridget talking about, yes, okay.
So, I don't know if any of you have heard, there's a thing called one thing you can do with firearms. I always say there's two things you can do. Ray and I have been out in the community a lot and people are asking like, what can we do now? So, in addition to the extreme risk protection orders, safe storage is, one of the best things that you can do to, prevent gun violence. So with secure storage, there are cable locks, which I do have in my office, and I think we have some here. So those are kind of the first step, and they're free. Also, there's a lockbox or a gun safe, which is a little more expensive and high tech, but that is the best way. One of the things I always say is, like right now, like I don't own firearms. My father does. And when I had kids, he went out and got a passcode, and then you also need a key. So as our children get older, like especially teenagers, they are gonna be able to find that key and they're gonna be able to unlock it. So we always really say as the kids get older, your firearm storage should grow with that child and get a little more technical, like savvy. One of the other reasons for secure storage, like I said, or maybe I didn't say this, but I'll say it again. Right now in the United States, firearms are the #1 killer in children. So that is 17 and below. Minnesota, it's #2. which honestly is pretty high for, how many, stronger gun laws that we have compared to other states. Also, a lot of our kids have now come out of a pandemic, which has been very mentally challenging for them. So, making sure that secure storage, is available in homes, because as all of us have been teenagers at one point, and we know that Mayor Minnetonka gave a good example of you have a broken heart and you think, everything is just not doing great. So doing that secure storage, shows that it gives people, like we say, time and space. It gives you time to think about what you're doing, how this could affect you long term, how could this affect your life and, your family, and that your life does mean something. So, and then also kind of trusted individual hold for the time being. So, right now, I just went through with my own family. Someone has mental health or, maybe dementia, just temporary holding the firearms with someone else until, you can get the legal process figured out to do a legal transfer of those firearms. Ensuring that, ammunition is separate from the firearm. That is another thing that I show is, have it locked up and have the ammunition in a completely separate area. We always say too, if you think your kids don't know where your firearm is, they 100% know. They know everything. They watch you. They hear you. My kids can climb up my shelving in my bedroom and they can get to the top. Putting it in a shoebox is not safe storage. They go through, everything. And then, something else I always like to make sure everyone knows about safe storage is anyone that is as young as the age of 2 can pull a trigger. We have seen a lot of that in, we've seen a couple of cases in Minnesota. And it is, unfortunately, we don't have right now a safe storage law for everyone, 0 to 100. There is a negligent storage law for anyone, so adolescents to children from 17 and under. If you do leave, it is illegal for anyone with children present in the home to leave their firearm loaded and unsecured. Oh, and then Raina's put the ammunition in the freezer. That was something I learned from working with Raina. So it gives the cold blast of air.
I learned it from a
Military,
guy.
yeah.
Hey.
I think it's a question.
Thank you for the presentation, and I'm curious, could you say more about the availability of gun locks and cable locks, for example, maybe through local police agencies in Hennepin County?
Yeah.
And what's the best way to try to connect a person living anywhere in Hennepin County with a gun lock?
So yeah, we have them with the libraries. I think that was this year. So yeah, I don't think it's I live in St. Bonnie, so I live in the way west Hennepin. I don't think it's there, but law enforcement have them as well. And most of them, I know my police station, they have them in a box outside the window, the gun locks. So I have them. I'm trying to think if you go to any tablings. A lot of these places Be Smart, if you see a Be Smart table, Moms in Action, they have gun locks. Trying to think Department of Public Safety, if you go on their website, they have them too, so.
I just wanna add, we have a box of them up front at the registration table too, so if you need one or wanna bring one home or know a friend, please feel free, they're out there as well.
Okay. And then just some resources, so this is the website to get forms. The Voluntary Firearm Storage in Minnesota. This is the Domestic Resource Center, so this is where I am. I always encourage people, if you're making any referrals, to make sure that they can call, because like I said, I live out in Western Hennepin County, I know it's hard to get downtown. I can do these over the phone very easily. It usually takes me petition maybe 45 minutes to an hour, kind of depending, and then I'm able to submit, Siri said, I also have the connection with District Court, and I've gotten one pushed through, like approved within probably an hour and a half, so.
Yeah, I think somebody was, no, it's okay. If we can get something filed, court administration gets a little crabby, but I understand why, but if we get something filed by 3:30, we should be able to get it by that day. It's stressful for them, so we try to not do that to them. It's not very nice, but sometimes that's where you're at. And then if you need one, either overnight or it's a weekend, talk to law enforcement. Law enforcement does have the ability, if that makes sense, to get after hours ERPOs. But in general, we get them issued that day, they get in law enforcement's hands, and then depending on exactly what's going on, how much research law enforcement needs to do in prep, but often they're getting served, the next day or sooner. It just kind of depends on what's going on.
So my question is, our program serves multiple people, and with there being an abundance or not enough storage for guns, if we're receiving them into our office, we're locking them up, where do we send them if we can't send them to law enforcement because they have an overabundance in those storage?
I'm not sure, so law enforcement has to take them.
Okay.
They would have to figure that out. If somebody has an extremist protection order, and again, they are responding in an extremist protection order, law enforcement has to take their firearms. They cannot say no.
So let's say that they're turning their guns into our offices.
Okay, who do you work for?
I'm sorry, Agape Oasis.
Okay, okay.
Let's say
Okay.
that our men's program, because we're asking our men and our youth to turn in their firearms,
Okay.
whether they have an OFP or not.
Yeah.
And so as we are receiving them, or when we receive them, where do we send them? Do we call these places if it has nothing to do with an OFP or?
If you guys are taking possession of firearms, then you guys need to figure out what you're gonna do with them. If you're gonna move them, then you're gonna need permission from the people who own them to send them anywhere else. So, I think that's a conversation within your organization. Happy to be involved in that conversation, but, that's something you guys will need to talk about if you're gonna take firearms. Other questions? Yeah. We just have there's our contact information, our fancy, email address, you can email us at, you can always, reach us through DASK, that's DASK's phone number. We're happy to help, have training, we'll travel.
We're gonna go on tour.
Yep.
Any other questions?
Thanks, everybody.